We thank you so much for watching Law School Made Easy at Law School Made Easy 256. We want to discuss today evidence law, the law of evidence 1, and we want to do the introduction to this briefly, especially. We want to look at section 58 and section 59 because this is the core of evidence law. Remember, when we talk about evidence, we mean that how you bring up evidence to beef up your case in court. So we are going to discuss how evidence must be brought in court, and this is the backbone. This is the introduction to evidence law. And when you appreciate this section 58 and 59 of the Evidence Act, then the rest is going to be history. However, we ask you to double check if you have subscribed to our channel. It's very important. We ask you to subscribe to our channels. Double check if you have subscribed. If you have not yet, please hit the button. I mean, this is the only thing you give to us. This is what we actually benefit from. That's why we are able to always come back and discuss these videos. That's when you subscribe. So just hit the subscription button and the rest will be history. So now let's deep dive into the law of evidence. Now, when you look at section 58, it tells you that apart from documentary evidence, the rest of evidence must be oral. What does this mean? This means that when you are tendering in any evidence in court, your evidence must be oral, apart from documents. Okay? So meaning that every evidence, every witness you have with you, when you get them to court, what they are going to give you is oral evidence under section 58. Now, one will ask why we are discussing these sections. Because even when you are doing res gestae, even when you are answering hearsay, if you are answering character evidence, if you are answering expert evidence, all that, the core, the starting point is to appreciate section 58 and 59. And under section 59, they tell you that oral evidence must be direct. Now, the evidence we have discussed above, which actually says that apart from documentary evidence, all the other evidence brought to court must be the one that is oral. Now, they are telling you under section 59 that oral evidence must be direct, and they have given you categories of evidence which is direct, evidence which is relevant. Okay? And now, let's first appreciate the equation before we go to section 59. Let's appreciate the equation. Now, members, note, under evidence law, if the evidence brought is direct, then it means that that evidence is relevant evidence. It's relevant. And the fact that that evidence is relevant, it now means that it is admissible in court. So in under 59, the only evidence that is admissible in court is the evidence that is direct, oral evidence, and is direct. And the Act has gone ahead under section 59 to explain to us that oral evidence must be direct. And they have given us 4 scenarios where oral evidence, what they mean by directness of oral evidence. Number 1, they are saying that if it is the evidence of someone who saw, who have seen, it must be someone who actually saw. The evidence is direct. Okay? It must be someone who actually saw. And they have gone ahead and say that if it is the evidence of someone who says I had, it must be someone who actually had. you had by yourself. That is what they mean by direct. And they are saying, if it is the evidence that can be perceived by any of the other senses. Remember already, we have the senses discussed. We have the sense of hearing and seeing, which now they are saying, if it is by any other sense, perceived by any other sense, still it must be that somebody who says, I perceived by any other sense, maybe smelling. Okay? Then under subsection 4, they are saying that if it is that opinion that is perceived or on any of the grounds, still it must be that somebody who holds that opinion on those grounds. That is what they call direct evidence under section 59. And now, the direct evidence we have just talked about, it means that that is the only evidence that is accepted in the courts of law. That when you get a case, establish, do you have those people that we have discussed? Is there someone who saw, who says I saw? Is there somebody who says I had? Is there somebody who was perceived by any other sense? Is there someone who holds the opinion on that definite ground? Okay, that is oral evidence. It must be direct. Now, when it is direct, direct equals to relevancy. If you have a scenario and the one Walter comes up and says, Mia was there, I saw, it means that that evidence is going to be direct. It is coming from someone who actually saw. Now, we have said direct evidence equals to relevant evidence. It becomes relevant, and therefore, the moment evidence is relevant, it will be admissible in court. However, there is some other evidence which is indirect. It does not fall under the category of 59. So, when you don't have direct evidence, do we stop the case there? This should be the question. Does the case end there? We don't continue to ensure that we have administered justice to others? That would be now the question that we must ask ourselves. Now, the case does not stop there. There is what we call indirect evidence. Now, relating to section 59, indirect evidence is irrelevant and therefore inadmissible. Okay? The only evidence which is allowed in court is direct evidence under section 59. So this, why we are discussing 59, this is the backbone, this is the start of the evidence law. Of course, in our subsequent video, we are now going to discuss the indirect messages. If somebody says, I had hearsay evidence is indirect. It doesn't fall in the category of 59. So therefore, because it is indirect, it is inadmissible. But my question is, it should be running in our heads. If we don't have a witness who falls under the category of 59, we don't have somebody who saw, we don't have somebody who heard, we don't have somebody who perceived by any of the senses. Does the case end there? Someone has raped. Does the case end there? The case doesn't end here, because we have the hearsay evidences, which is indirect and therefore irrelevant and therefore inadmissible. However, there are other ways when we discuss res gestae where that other evidence which is indirect can be qualified and courts will accept it. But that one is for another day. We are saying the only evidence that court allows is the evidence under 59. Let me make this a bit more clear to our viewers who follow us on this channel. Take a scenario that They are going to give you problem questions, different questions when we are answering. Different questions are going to be set under evidence law. But when they give you any problem question, first look out for the evidence in 59, because that is the only evidence that is allowed. So the moment you establish in your problem question, there is no anyone, you don't have any witness that falls under the category in 59, then it means you have gone to the other part of res gestae, which helps us to make indirect evidence, to make it relevant and therefore admissible. Okay, of course, like we agreed in the other videos, we shall bring up this. So that is the starting point. The only evidence which is allowed in court is under section 59, and it says oral evidence must be direct, and they have given us 4 scenarios where that evidence is direct. And of course, like I promised, in our subsequent video we shall discuss section 4 and 5, res gestae, the whole of res gestae. We discuss it. We shall discuss the hearsay, we shall discuss character evidence, we shall discuss expert opinion, we shall discuss the confessions, and very many others. So that is the law of evidence. We thank you so much for watching Law School Made Easy at Law School Made Easy 256. Subscribe, share, like our videos. Until next time, thank you. Cheers.